Good morning. My name is Kelli Block. I'm also a Scopelitis. Similar to Brandon's practice where he sort of handles all things regulatory, I do a lot of work with independent contractor issues. And that stems in all sorts of different areas, particularly in recent years where we've seen a lot of activity with efforts by states and federal agencies as well as the plaintiffs' bar to engage in an effort to reclassify independent contractors as employees for various purposes. Brandon talked about in his practice, sometimes they'll go in and do preemptive audits of carriers for an internal audit on their DOT compliance status. We do similar things with independent contractor compliance status. Come in and take a look at operations to see what things you could improve upon to lower your risk profile, to sort of make sure you're not low-hanging fruit for either the plaintiff's bar or an agency on independent contractor issues. And then we also help advise clients when they're looking to implement new operational procedures, not just at an independent contractor basis, but how those procedures may impact your business on an operations-wide level for independent contractor status issues, also various wage and hour compliance issues and things of that nature. Where I want to start today is to just sort of, before we dive into all these various issues facing independent contractors, is some background on the important tests for you to think about when you're thinking about whether your independent contractors you engage are going to look more like independent contractors or employees to various agencies and plaintiffs' attorneys. And the top test is the right to control test, and that's actually the test that they apply here in Kentucky for work comp, unemployment tax, as well as wage and hour purposes. The right to control test they apply in Kentucky is a little bit more restrictive than the federal test and the test applied in some other states, and as a result, Kentucky isn't necessarily a terribly favorable state when you're looking at the classification of owner-operators as independent contractors. But the overarching theme of the right to control test is always going to be, does the carrier or the owner-operator control the manner and means of completing the work? And so they're looking for ways where the carrier is putting his hand or its hand on the independent contractor and really guiding the details of that independent contractor's work. And that right to control test is a component of all of the other tests that are there, and those are the various tests that are applied under different laws for different purposes, but that control factor is really important to all of them. And I'm going to try to do something and see how technologically savvy I am, because I'm actually going to skip ahead because I want to follow up on something Brandon talked about. And then I'll go backwards. But the reason I bring up that control factor at the very beginning is because following on the heels of Brandon's presentation where he's talking about all of these regulations that carriers have to follow, and here's all the things you have to do to make sure your company's compliant, your operations are compliant, your drivers are compliant, etc. Well, once you've implemented all of the strategies you need to implement to get your company into compliance, it sure feels an awful lot like you're controlling those independent contractors. So I've just told you, you can't control if you want them to maintain their independent contractor status. And one of the ways that we've found, so there you just had a preview of everything else I'm going to talk about, but one of the things that courts seem apt to adopt in many jurisdictions, and Kentucky is one where we've had some success with this argument, is that when you're looking at the control test, when you're looking at the evidence of why a carrier has imposed certain controls, that means something. And if the control the carrier is imposing comes from government regulations, things that they have to do in order to comply with the law, then they're going to look at that as a neutral factor and take the control out of it. Because in that case, it's not the carrier who's controlling the owner-operator, it's the federal government. So we can't really hold that against the carrier. And it would be against public policy to do so, because we don't want to discourage carriers from following the law, especially when those laws are implemented to protect the motoring public. So for that reason, we've had a lot of success arguing, hey, don't look at their compliance with the basics. Don't look at their compliance with the safety regulations. Don't look at their compliance with the leasing regulations. These things are all in place to protect the public. Don't scare motor carriers away from complying with those things. So one place, though, where this is coming into play, and it's a really hot topic right now, is with the use of telematics devices. And this follows up on Brandon's presentation because with the ELD mandate implementation coming upon us, what a lot of carriers are doing when they're looking at the ELDs available on the market, they're saying, okay, if I have to make my owner-operators or employee drivers, for that matter, comply with the ELD mandate, I'm going to go ahead and add some other technology to that too, because a lot of these ELDs that are being offered on the market have a whole lot of other features in addition to just being able to electronically monitor the logs. So when I'm talking about telematics, I'm not talking though just about the ELDs, I'm talking about all of those other things that can be included with the ELD technology, like your hard braking event status, hard cornering event status, things of that nature. Sometimes, some of them are even offering in-cab monitoring. And so the benefits that we're looking at this scale, and we have all these benefits of ELD mandate compliance, right? First of all, you have to do it. Second of all, particularly if you comply with the ELD mandate and add some of these other telematics features, you're going to see the arguably increased productivity and increased safety in your operations. But then that has to be balanced against, when you're utilizing independent contractors, issues related to independent contractor misclassification exposure, as well as issues related to the leasing regulations when we start thinking about who's going to pay for these ELD devices and or telematics devices. And so things get a little more difficult to consider when you're dealing with an independent contractor fleet. I'm going to skip over a little of this because Brennan's already talked about it, but those telematics features that we talked about, the problem with those when you're talking about an independent contractor fleet is that those telematics features go above and beyond what the ELD mandate requires. So the more bells and whistles you add to whatever ELD device you decide to implement company-wide, the more you're walking yourself on the risk side of becoming that low-hanging fruit for an independent contractor misclassification claim or generating evidence that won't favor you in the event that you have to defend such a claim. Another issue when you're talking about the telematics devices in the context of IC status considerations relate to part of the reason why telematics devices that capture a lot of vehicle data regarding the vehicle's speed, braking, things of that nature, where do you really get the most bang for your buck? It's where you take that data that's driven by the device and you counsel your drivers and say, hey, we've been reviewing your data, and as a result, we know you're prone to speeding, you're prone to this, you're prone to that, or you're doing a good job with this and you're doing a good job with that. Well, once you start counseling an independent contractor owner-operator on issues like that, it very much looks like you're getting in there and you're delving into the day-to-day driving activity that very much needs to be the province of the owner-operator, so long as the owner-operator is complying with the law. So you can say, hey, you sped, don't speed, but you can't say, you know, your fuel efficiency would be an awful lot better if you kept your speed to this rate, or, you know, things of that nature that people are often doing as a result of the data generated from the telematics devices. Now, this doesn't mean that if you implement a telematics device that does something greater than what the ELD mandate requires, that you're going to automatically expose yourself for an IC misclassification determination. There's a lot of case law where telematics devices have been deemed neutral in the determination of whether an owner-operator is an independent contractor. And the best, you know, argument for not allowing it to weigh against independent contractor status is that it's something that's being done to increase safety, increase awareness, and oftentimes with the GPS capabilities, it's something that's being done at the request of your customers, not you, because your customers demand that they have access to information regarding specifically where their freight is at all times. So those are arguments that can be made, but those are defenses. So if you can put yourself in a position to not get to where you need to raise those defenses, you're certainly ahead of the game. And now I'm going to go back to the beginning because I just wanted to get that telematics stuff out of the way. So why are we talking about all this, and what is it that's driven this interest in independent contractor misclassification, particularly in the last 2 years or so? And it comes from a variety of areas, but where we really started seeing an increase in efforts to deem independent contractors misclassified, it would have been in the midst of the recession, where we had states and federal governments seeking to fill their coffers, and they see motor carriers as this great target where they can come in and look at the independent contractor status for various purposes, unemployment tax, federal wage and hour violations and the like, and look to reclassify these independent contractors as employees, and as a result capture revenue for the states. Also following some big headline cases, FedEx versus Estrada in 2008 would be the big one, where there was a class action filed against a motor carrier alleging that the motor carrier had misclassified all of the owner-operators as independent contractors. When that court deemed those independent contractors employees, it really got the attention of the plaintiff's bar, and that's where we saw just this windfall of all of these cases alleging misclassification. So more recently, what we've seen at the federal level is the United States Department of Labor last year issued an independent contractor status memorandum, and this put independent contractor status issues on the map, not just at the federal level, but again, it's something else that's further piqued the interest of the plaintiff's bar. And what the DOL said in this memorandum is that in the DOL administrator's opinion, almost everybody is an employee. It's real hard to be an independent contractor in the United States under federal law. And essentially, they say the only way you can do it is if, as a contractor, you have multiple accounts. So you're working for multiple firms. So translated to the trucking industry, as an independent contractor, they're looking for owner-operators who operate under the motor carrier authority of multiple carriers, not just one. Of course, that's really hard because the leasing regulations say can't do that. So what do we do? Well, there are some paths ahead and some ways to work around that. And again, it's not the only factor, but it's certainly something on their radar. And we'll get to those a little later in the presentation. But just a little further at talking about the DOL and what it's trying to do with moving liability upstream. Just earlier this year, now they're saying we're not only going to be looking at independent contractor misclassification, we're also going to be looking for joint employer liability. And where this would come into play for motor carriers, it's going to be when you have your fleet operators or fleet contractors who have multiple trucks leased on with you, 5 or 6 trucks, and they either employ or engage drivers to operate those trucks as independent contractors. It's taking those 5 or 6 drivers and reclassifying all of them as jointly employed by you, the motor carrier, and the fleet operator, rendering you liable for all of the employee benefits that those employees would obtain, to the extent that their direct employer, the fleet operator, isn't providing those benefits. To make matters even more fun, this isn't just the DOL issuing all of this guidance. The DOL is also giving out a lot of money to support its efforts. In the last 3 years or so, the DOL has granted over $60 million in grants to state unemployment tax departments. And they're issuing those grants to encourage state unemployment tax departments to police independent contractor misclassification. They've also entered memoranda of understanding with several states, including Kentucky, that say, not only are we giving you this grant money, and not only are we saying that you have to use this grant money or give it back to us, we're also saying that if you take this grant money, if you go out there and you find someone who's misclassified employees as independent contractors, you have to tell us about it. so that we can come in and we can look and make sure that they've classified them properly for federal wage and hour purposes. And then the DOL and the IRS have also entered an agreement that says if the DOL decides that a company has misclassified employees as independent contractors, it's going to share that information with the IRS, and vice versa when the IRS is involved. And then we have this class action litigation going on, and where that comes into play is going to be in the motor carrier industry, if you're dealing mostly with over-the-road drivers and folks who would otherwise be subject to the Motor Carrier Act overtime exemption, chances are that you're not going to see a minimum wage or overtime claim. What you're more likely to see is a misclassification claim brought by a private party that alleges you've misclassified these You've misclassified these employees as independent contractors, and as a result, every time you've deducted something from their settlement, you've violated a wage deduction law that's designed to protect employees, to keep employers from taking deductions from their wages. So real hot areas for this would be with insurance, to the extent you're facilitating any insurance programs and you're deducting insurance premiums from the owner-operator settlements. That's a huge area that plaintiffs' attorneys see as a big pot of damages when they're looking at what types of things are being deducted. Another thing is going to be with other types of facilitated equipment purchases is another big area. If you are leasing, if your independent contractors are leasing their trucks from either your company, an affiliated company, or even a third party, and you're facilitating that lease by deducting the lease payment from their settlement and then transferring the lease payment over to the equipment owner, that's another area that these folks are going to look at and say, ooh, that looks like money, that looks like something we can get our hands on. The good news is, on that one, in Kentucky, is that you do have a pretty favorable wage deduction statute. So under Kentucky law, you're okay to take deductions even from an employee's wages, so long as those deductions don't amount to an unlawful kickback where you're taking them below minimum wage. So one thing that we recommend to carriers in states like that is to take a real hard look at what your effective rate would be when you're taking into account all of the deductions that you take out from settlements, to see, does it look like if this guy was an employee, he'd be making minimum wage even after those deductions, because that sort of takes a little bit of the risk out of it, because it's a defense that can be raised in the event they bring a misclassification claim. The other area where we're seeing the attacks is, like I said, on the unemployment and workers' comp fronts. And from talking to these folks and some folks during the breaks, it sounds like workers' comp is an area where Kentucky is pretty active with their state fund, coming in and taking a hard look at carriers to ensure that they're properly classified folks as either employees or independent contractors. And again, when they're looking both for unemployment tax purposes and workers' comp purposes, the test that they're applying is this control test, where they're looking at, does it look to us like the carrier's exercising control over the owner-operator in a manner that seems more like an employer than a general contractor working with subcontractors. With all that said, there have been some successes. In fact, we've recently seen some favorable IC statutes enacted in several states. Kentucky's not one of them, but roughly 28 states have either workers' compensation or unemployment tax exemptions that can be applied to owner-operators to remove them from the protections otherwise afforded to employees for unemployment tax and workers' comp purposes. And even today, this year, we're still seeing new legislation coming into play. We're still seeing more and more states enacting those exemptions. One of your neighbor states, Tennessee, has some great exemptions in place, not only for unemployment tax and workers' compensation purposes, but also for wage and hour purposes. And essentially, if you have an independent contractor, owner-operator, furnishing a truck to a motor carrier under an independent contractor agreement that complies with the leasing regulations, they're going to deem those drivers exempt for unemployment tax, workers' comp, and wage and hour purposes in Tennessee. And we've also seen some other victories as well on cases in the workers' comp arena and the unemployment tax arena. And so just to put things in perspective, even though, yes, this is scary and there's all this bad news and everyone's really actively trying to engage in efforts to reclassify independent contractors as employees, when you look at the country as a whole, there's an awful lot of green on this map, and the green represents states on this map where there's either favorable case law or favorable statutory law saying that we have some pretty good arguments for defending the independent contractor status of owner-operators for unemployment tax purposes. You'll see the West Coast, California, not so good. In fact, California's terrible for everything related to their wage and hour laws, their class action experience. It's just a real rough place to do business. That would be a whole separate presentation. If any of you folks do a lot of business in California, we could talk about that all day. And then some of your states on the East Coast are also going to be a little bit more difficult. We've seen New Jersey and New Hampshire in particular to be particularly active. Illinois, although not difficult for unemployment tax purposes, it is a difficult state for workers' compensation. Other difficult states for workers' compensation purposes, again, we're going to have California and Nevada. North Carolina is also really tough. And these states are tough particularly because they have statutes in play that say if you don't have workers' compensation, you basically can't operate as an owner-operator based in one of these states without work comp. You have to have it, regardless of whether you're going to try to defend their independent contractor status for other purposes, like unemployment tax or wage and hour purposes. You're going to have a real hard time overcoming the test for independent contractor status in those red states and some of the yellow states. But there's still a lot of green, so that's good. So when we look at the road ahead, what have some folks been doing now that things have been getting more difficult? One thing we have to think about is this, with the upcoming election, things could change. We don't know what's going to happen with that, but it might ease the burden on carriers who are facing this attack on the IC status. But at least until then, what can you do to try to keep your company off the radar of both plaintiffs' attorneys and state and federal regulators when it comes to IC status issues? And so these aren't necessarily things that are going to carry the day, but these are things that you can do that makes you look like a more difficult target. And so that can help lower your risk profile and then also make it more difficult for an adversary to demonstrate that you have misclassified independent contractors in the event they do bring a claim. One of the first ones up there, this business entity contractor model, essentially what that's saying is we have a lot of clients who've implemented this, particularly in New York, because it's very favorable in New York. Ohio is another state where it's very favorable to do this, where you engage only owner-operators who are incorporated or organized as an LLC. You've got to do more than just engage them. You have to treat them like a corporation or an LLC, meaning your contract is with the business entity and all of your communications with the contractor are via his business entity and whoever he has named as his principal officer or contact for the company. Another area where we've seen is with multi-unit contractor model. We have a lot of companies, clients who have sort of narrowed the scope of the pool of contractors they engage to include only those who are bringing multiple trucks to the table. So they're no longer doing business with your one-man, one-truck owner-operators. Instead, they're saying, hey, we're only going to do business in an arm's-length relationship with true business owners who have 3 or more trucks, and they've seated those trucks with drivers. And in some cases, they've even gone so far to say, we're also not going to do business with you unless you're treating those drivers like employees and you're doing everything that an employer needs to do to cover those drivers. So you have work comp in place for them, you're paying into the state unemployment tax fund if it's required in that state, et cetera. And in doing that, the carrier doesn't only lower its risk profile, but it also makes it less likely for the carrier to face damages in the event of a misclassification claim, because you're taking the incentive for bringing the claim out of the picture in the first place by reducing the pot of potential damages. If your direct contractor is paying minimum wage and paying into unemployment and covering them with work comp, what do they have to go after you, the carrier, for? Now, of course, what happens, though, is you could get yourself into a situation where you face liability as a joint employer in the event that your contractor isn't following all of those rules and treating his drivers like employees and doing everything he needs to do. Then you're in a position where, if you're deemed the joint employer, you could be on the hook. However, we've found, generally speaking, it's sometimes a little easier to defend your status as a motor carrier as not a joint employer than it is to defend your status as a direct employer of a one-man, one-truck driver, because the test that's applied works out a little bit more favorably in the transportation industry. The settlement carrier model has also gained a lot of steam. This is something that we see a large section of our final mile delivery companies in doing. We've also seen this working fairly well in the drayage sector. And what it is essentially where the motor carrier converts its operations from motor carrier specific to operating as a property broker or freight forwarder, and then only engaging third-party carriers as independent contractors to perform the transportation and delivery services that the former carrier arranges as a property broker or freight forwarder. And in doing that, you step away from a lot of those requirements that are imposed on you as a motor carrier to pass along, because now those requirements become the burden of the third-party motor carrier you're engaging. Even if that third motor carrier is a one-man, one-truck, he's still the motor carrier. He's still the one who's on the hook for everything associated with that. And once you're doing business with him as a motor carrier, to regulators and plaintiffs' attorneys, it looks a lot more like that arm's length relationship that they want to see when they're deciding whether they think this person's really an employee or not. The non-deduct model is another one that we've seen a lot of carriers go to, albeit with some strife, and some carriers have gone to it and then backed out and had to go back because they find it just doesn't work real well. And it's pretty self-explanatory. It's rather than facilitating anything for your owner-operators, such as insurance, equipment, things of that nature, take that out of the game. Just have any third-party vendors they're dealing with, invoice them, deal with them directly. That creates all kinds of great evidence if you can do it, because it shows now you've got these owner operators out there engaging on the open market. They're negotiating with all kinds of vendors rather than just the ones you're referring them to, and they're doing it on their own. They're negotiating. They're looking for the best bargain. The problem is a lot of these vendors don't want to do business with the one-man, one-truck owner-operators. They're looking for the credit backing of the motor carrier before they're willing to engage in that, and the motor carrier offers that layer of protection that really simplifies it for the vendor. And then we also have the owner-operators, even if they will do, even if the vendors will do business with them, a lot of times they just can't afford it on the one-off basis that they can otherwise afford through the lower rates that carriers have negotiated on behalf of their owner-operator force. So it's a great direction to go, but it really does depend on the credit level of the folks who you're contracting with. This last bullet on the road ahead actually goes into a bigger topic, and it's entrepreneur sensitivity with your recruiting. And this is what I think, in my experience from dealing with a lot of carriers, is one of the hardest things to do, but it's one of the most effective. Trying to change the carrier's mindset and the independent contractor mindset to really live and breathe what the independent contractor model is supposed to be. And that's that you as a carrier are engaging this independent contractor to furnish equipment and delivery services, and you're doing it with them as a business. They are a business. They need to be making their own decisions. They need to be taking advantage of entrepreneurial opportunities, and the more of that they do, the more evidence you're generating to demonstrate that the owner-operator is in control. And it's a lot easier to prove independent contractor status when you have affirmative evidence of the owner-operators engaging in entrepreneurial activity than it is to prove a negative when you're saying, when your evidence is, well, we don't control this, we don't control that, we the carrier aren't doing these things. It's much better if you can create an environment where you're showing, here's all of the things that the owner-operator does. Here are the decisions the owner-operator makes. Here's how the owner-operator decides how he's going to generate profit or recognize loss in his company. You have to look both at your relationship with the owner-operator on an operational level, as well as the independent contractor agreement that underpins that relationship. And not only does that contract need to be well drafted in the first instance, you need to actually, in practice, abide by the things that that contract says, really giving the independent contractor the freedoms that he should enjoy as an independent contractor, third-party vendor who's furnishing equipment and driving services to complete the transportation and delivery services you've arranged as a motor carrier performing logistics services. One of the ways to put all of that together and really look at this in a fashion that how are we engaging in a true independent contractor relationship and generating that affirmative evidence that's going to help us demonstrate this owner-operator is an independent contractor, as opposed to proving he's not an employee. And we've kind of gone with this as this carrot versus stick approach. And guess which one's better? It's not stick. No, stick is bad. The carrot approach is really what you need to do to generate the affirmative evidence that you want, because you're in a contractual relationship. You want to keep these folks as vendors. This isn't an employee you can control and order around and use the stick. So some examples. So we have an IC. The IC becomes disqualified for one reason or another. He's failed his drug test. He's had a preventable accident. Something happens. He's disqualified. If you're using the stick approach, you might say, well, that's a for-cause reason for termination under your contract. You're out of here. You're done. You're terminated. Get lost. Well, that's all well and good, but that sounds an awful lot like employment at will. It sounds like you've just decided, hey, you messed up on the job, you're fired. We can't fire contractors. But what we can do is, if our contract has a provision in it, as it should, that says that the independent contractor is furnishing a truck and driving services, and that those driving services do not need to be personally furnished by the contractor himself. Rather, they can be furnished by any qualified driver, so long as they meet the DOT requirements and some additional requirements a carrier may impose. Then we need to actually give him the opportunity to replace himself with another driver. Now, will it happen? We don't know, and oftentimes it doesn't. He doesn't have the financial ability to pay someone else to sit in his seat while he works on getting himself qualified again. But what you do want to do is record your efforts to give him that opportunity. Show in writing that you've said you're disqualified. However, under the terms of your contract, you are offered an opportunity to have someone else drive this truck. If you cannot find someone else to drive your truck within X number of days, then we'll need to, terminate the contract pursuant to the termination clause. Another thing is, I'm sure a lot of you have a provision in your contract that says that the carrier does not agree to provide the contractor with any specific volume of loads, and the contractor does not agree to service you for any specific number of loads. Rather, the contractor is just agreeing to make his equipment available to you for the term of the contract. Well, what we see oftentimes is carriers saying, yeah, I know that your contract says something about you have the opportunity to accept or reject any delivery opportunity we offer you, but if you reject this one, you're terminated. You're out of here. Well, that generates bad evidence in the same way that the prior one does. That looks like forced dispatch. And forced dispatch is something that courts, regulators, adversaries are all going to look at as a red flag for a misclassification situation, because one of the hallmarks of independent contractor status is that the owner-operator has the opportunity to generate profit or loss based on what he thinks looks like a good load. So if you're offering him a load and he doesn't like it, he should have the opportunity to negotiate for a better rate, negotiate for better terms, and if he can't get to the deal he wants, he should be able to refuse that load without repercussion. So if you punish him through terminating him or starting to give him bad loads because he keeps saying no to what you deem good loads, that's going to generate bad evidence. If instead you say, okay, you refuse the load, you just go on down the line, you offer it to your next contractor, you're generating evidence, particularly if you document each time a contractor has rejected a load offer, you're documenting his ability to make those decisions. We do have ways to help. It's an idea of sort of progressive contract breach that we could help you with if you have a serial offender, someone who's constantly rejecting loads and really isn't giving you the capacity that he's agreed to give you. There are ways to go about that contractually to help you terminate the contract in a way that still doesn't put you in quite as tight of a spot in the event you find yourself defending a misclassification claim. Similarly, if this is one that we run into all the time, we'll get calls from clients and they'll say, hey, I've got this contractor, he's a one-man, one-truck guy, and he's rude, he's belligerent, he swears at the girls in the office all the time, he smells, he's dirty. We don't want this guy around anymore, but there's nothing in his contract that says we can terminate him because we don't like him. When we get those calls, we can help with it, but oftentimes what will happen is that guy does just get terminated. And he either gets terminated or the contractors will send business advice notices that say, you need to clean up your act, or they start sort of, I can't think of the word I want to use here, but terminating him without actually terminating by giving him bad loads and sort of pushing him out implicitly. Rather than going that approach, what we found to be something that creates better evidence is to avoid that circumstance in the first instance by rewarding contractors for good behavior, rewarding them for things like a clean appearance that promotes your company's brand, reward them with incentives to act in an appropriate way rather than punishing them when they act in a way that doesn't fit your business image. Another one, so we talked about this earlier with, we have with the DOL particularly saying if this guy doesn't work for more than one carrier, we're going to look at him, he's an employee, that's the only thing that we're going to look at. Well, while the leasing regulations do require that the carrier maintain exclusive control, possession, and use of the truck for the duration of the lease, there are provisions in the leasing regulations that authorize trip leasing. It's tricky, it's complicated, it's a pain, but it can be done. And if you get the right procedures in place and you have the right documents in place to help you authorize trip leasing when it's requested, the evidence that generates of independent contractor status is fantastic, because then you have evidence. Not only do you tell this owner-operator he can drive for other people if he wants to, you have evidence of him actually doing it. The only other way really around the DOL position, leaving the legal side of it aside, that the DOL is wrong, that's not part of the test, and we have all sorts of legal arguments, but just practically speaking, the only other way is if you can engage in a multi-truck owner who is leasing part of his fleet to you and part of his fleet to another carrier. But those are diamonds. Those guys are hard to find, and we recognize that. But we do, again, have ways to help make trip leasing something that's actually doable if it's something that the carrier is willing to implement. Another carrot versus stick is what we talked about earlier, is where you have the independent contractors who want to source their own products. They want to go out and service a vendor that's not the same vendor that you're referring everyone else to. It gets tricky because it makes it more difficult in your operations. It makes it administratively burdensome when you have different owner-operators using different services. But if you can allow your owner-operators to do that, and you have evidence of a percentage of owner-operators who are using a vendor other than the one the majority of your owner-operators are using, it generates favorable evidence, and it's going to be really helpful to you in the event of a misclassification claim. With all of that said, you also have to make sure that the vendors they're using are providing them with services and products that are compliant with whatever you have under the contract as what's required. If it's the ELD mandate's actually one area where this will come into play for contractors, and it's to the extent that the motor carrier is going to require the contractor to bear the cost of purchasing and installing the ELD. The carrier is most likely going to have a preferred vendor that the carrier wants the contractors to use, which makes a whole lot of sense from not only for various purposes, but namely on the back end side of it in your back office, that it's going to be a lot easier to administer the reporting to the FMCSA if you're using one system across your fleet. However, if you are going to require the contractors to pay for their own, it's one where you actually really need to let the contractors go out and source their own ELD rather than going through the specific vendor you've designated. If you don't do that, you're going to run into a problem with the federal leasing regulations. And I think I actually skipped over that slide when I was talking about it in telematics. So just to briefly touch on that. Well, no, you know what? I don't think I did. I'll come back to that. The other thing, just kind of wrapping this up with recruiting and getting into the owner-operator mindset and really thinking of your business as doing business with independent contractor owner-operators as third-party vendors, is you have to start at the top, and you have to start with your management. Start inside. If you come at it from the approach that we have to teach owner-operators how to be independent contractors, that's not going to be real helpful, because we shouldn't have to teach them anything. They're professional business entrepreneurs who know their jobs. Who can we teach? We can teach our own people. We can talk to our management about how they need to treat owner-operators as distinct individual businesses, not as employees. This gets more difficult if you're dealing with a mixed fleet. Do we have anybody who has a mixed fleet? You've got employee and independent contractor drivers? Okay, that's has to be terribly hard. I can't imagine in practice trying to wear a hat where I'm dealing with independent contractors on the left side and employee drivers on the right side, and trying to treat those two pools of people in a different way. But you really have to figure out a way to do it, because if you don't, it makes it so easy for the government to come in and say, there is nothing different about how you're treating those employees than those independent contractors. So sorry, we're not buying it. Those independent contractors need to be treated like employees too. Moreover, when you have a mixed fleet, it also creates trouble for purposes of securing safe harbor under some IRS rules that allow you to seek protection from retroactive employment tax assessments in the event of a misclassification determination. When you're dealing with a mixed fleet, if you don't have evidence that those two lines have been treated very differently, it's almost impossible to get that safe harbor under the IRS regulations. So what does all that mean? It means you have to come up with ways to ensure that you're treating both sides differently, and where that starts, again, is at the top. And one of the easiest places to do it is with the terminology. And so just using the right words when you're talking to one group or the other. You don't hire an independent contractor, you contract with the independent contractor. You don't fire an independent contractor, you terminate the ICOA. Contractors don't attend any kind of training. But they might go to a contract facilitation session where there is a business discussion held about what the company expects for purposes of fulfilling obligations under the ICOA. It seems like semantics because it is, but guess what? It's stuff that you can put down on paper in the event you have to defend your operations. So the last thing I'm going to talk about is some contractual issues, so with the ICOA itself, and some kind of hotspots that we've seen recently with agreements that kind of stem from the independent contractor operating agreement itself. And one of the things that we always like to start with when we're talking about the ICOAs is the importance of full compliance with the leasing regulations in writing in the ICOA itself, as well as in practice. So not only putting all the right words in the agreement, but living by those words in your day-to-day operations. Because when you do it, you can use the leasing regulations and everything that the leasing regulations obligate as defenses in the event of a misclassification claim. If you don't do it, it's awfully hard to point to the leasing regulations as a source of your defense for what you've done if what you're doing doesn't consistently comply with what the leasing regulations require. Also, some hotspots with the federal leasing regulation compliance issues, and I started to get off track a little earlier talking about ELDs and who pays for it. A real hotspot right now is with service fees being charged for telematics devices, ELDs, Qualcomm usage fees. And the reason it's become such a big issue is because last year there was a decision out of a Kansas district court that found that a motor carrier that charged a $15 weekly fee for Qualcomm usage to its owner-operators had violated the no forced purchase provision of the leasing regulations. That finding took a lot of folks aback because this carrier had the language in its lease agreement that the leasing regulations require, where it says, that we do not obligate you to purchase anything as a condition of entering into this contract. And with respect to the $15 a week Qualcomm fees, the carrier offered the owner-operators the opportunity to secure the Qualcomm services elsewhere, but in practice, all of the owner-operators were paying the $15 Qualcomm fee because how practical is it to go out and get Qualcomm services on your own? It's not. And it just made a lot more sense for the carrier to pass through the $15 fee. There's also a question in the case as to whether the carrier was truly passing through the fee directly or if the carrier was passing it through with a markup that wasn't disclosed. So with all of that said, that case has been appealed to the 10th Circuit. It was argued in March of this year, and we're expecting an opinion in the next 2 or 3 months. But that opinion is pretty scary because it brings things like charging for ELDs into question, particularly if you're in a situation where you think that it's most likely that you're going to need all of your owner-operators to use the same ELD. For the moment, carriers who have already started implementing their ELD program to get ahead of the game with the mandate coming up, the carriers are just absorbing the costs right now. And that's been our recommendation, because if you pass those costs along to the owner-operators, the chance of drawing a leasing regulations claim are pretty strong. Now, the flip side of that is that it's a little rough to absorb those costs on an independent contractor analysis side, because you're not supposed to pay for anything for the contractors that they need to do their business. However, each carrier needs to make their own risk evaluation, but if you're already facilitating some expenses for an owner-operator, if you're already absorbing some costs, we think that the ability to point to the ELD mandate as a defense for why the carrier is absorbing the cost, to point to the ELD mandate as why the carrier needs to absorb the cost because it needs one uniform ELD to effectively manage its fleet, that those defenses should sort of counterbalance the IC issue, whereas you're, at least right now, while this Trans Am decision is pending, you don't have really good solid arguments on the no force purchase side if you require them to purchase everyone purchase the same ELD. Term and termination provisions are another hot spot, particularly if you're on the West Coast. Chargebacks are another hot spot. And we talked about those earlier with wage deductions. That's why those are coming into play so much. In Kentucky, with your particular wage deduction law, one place where even if you can defend, settlement deductions related to insurance premiums, equipment costs, other types of maintenance, those things you can maybe defend under the wage statute itself. One place where you're going to have a hard time defending it under the wage statute is with claims. So if you do deductions, if you deduct from a contractor settlement as the result of cargo damage or damage to a customer's property, or like at a loading or unloading facility, that's an area where even using the Wage Act itself as a defense is going to be tricky, because Kentucky law says you can't charge an employee for damage that they cause in the scope and course of their employment. So to the extent that you do have a practice of charging contractors back for such damage claims, it's a really good idea to put some sort of bilateral process in play where there's a negotiation, the contractor has an opportunity to dispute the claim, has an opportunity to fix whatever the issue is on his own, rather than letting it be a completely unilateral decision by the carrier. Trip leasing, we've already talked about that. That's another hot area, is working a way into your contract to make sure that you not only allow trip leasing, but you in fact encourage it. This Defend Trade Secrets Act of 2016 went into effect a couple of months ago. It's something that is beneficial to carriers, and if it's something that you're interested in and you think that you want to take advantage of it to the extent you're trying to protect any of your any information that you could deem a trade secret under your agreement, then there is specific information that you need to include in your ICOA to be able to take advantage of it. We haven't really seen how well it plays out yet, but just the language itself seems very favorable to carriers, and it's something that, if this is an issue for you, you definitely want to get the right language in your agreements. Planning ahead for reclassification is another area where we've seen a lot of carriers going toward, and it's in including indemnification and rescission clauses in your contracts that would enable you, in the event you have a contractor bring a misclassification claim against you, you put something in the agreement that gives you the option, but doesn't mandate it, but gives you the option to say, in the event you are deemed to be an employee and this whole arrangement was wrong, then we want to rescind this agreement and take everyone back to where we started, to status quo. So you give us back everything we gave you, and we'll just go ahead and give you what you would have gotten as an employee. In practice, how well does that work? Courts aren't big fans of that arrangement. However, it is something that can be a deterrent with the language, and it's also something that can sometimes help in the negotiation if you're in the middle of defending a misclassification claim and you're at mediation. It's something that's at least a stick that you can use once you're I'm only advocating using a stick once you're already there and you're already fighting the misclassification claim, but it's something that some folks have found helpful. There's a big question right now, and this is actually just a recent case just in the last 2 weeks, on the enforceability of arbitration provisions. A lot of folks facing class actions have, and folks helping to defend class actions are advocating for these mandatory bilateral arbitration provisions that can help require class claims to be arbitrated on an individual basis. So again, it's another deterrent. It makes your company look less attractive to a class action plaintiff's attorney. The problem is that the Federal Arbitration Act has an exemption in it that applies to contracts of transportation workers, and oftentimes you end up in a debate about whether the contractors bringing the claim are employees or not before you even get to defending their status as employees. And sometimes what's been happening is there's a question as to whether that's something that happens in court or does it happen before the arbitrator. So enforcement of those mandatory arbitration clauses is really tricky because it's a strategy that you have to decide right away from the beginning as to whether you want to enforce it and gamble on not having to defend the status from the outset of the case instead of going through the case and having an opportunity to settle it and defend the status at a later date after the case has gotten a little further into the litigation. When we're talking about all these contractual best practices, one of the things that we do recommend is that carriers conduct what we call a desk audit. And a desk audit is just something that's particularly important for folks operating with a mixed fleet, because those tend to be the companies where we see oftentimes the use of similar documentation being given to employees and independent contractors. And there's an effort made to try to clean up the employee documents before you give them to independent contractors to make sure we're using all of those correct terms when we're dealing with an independent contractor, but those things slip through the cracks a lot. So particularly in a mixed fleet instance, but even in a pure independent contractor model, things like websites, policy handbooks, notices that are posted around the shop, oftentimes just force of nature, those are written to look an awful lot more like you're communicating with an employee, or on your website that you're marketing to secure employee drivers. You're looking to recruit independent contractors to be part of your team. Words like team, things like that, those are things that we recommend avoiding. And so you can do a desk audit to hit those hotspots and find the places where you're maybe using language that could be used against you in the event of a misclassification claim, or could be used as the red flag that puts you on the radar of a plaintiff's attorney or a regulatory agency in the first place. And that is all I have. Does anyone have any questions? Brandon got at least one question, so somebody has to ask me a question, because I'll hear about it in the car all the way home if you don't.
Right, so not to be negative Nancy, but it almost seems it's just easier to have employees than contractors. I mean, why would you drag yourself through all these? I mean, it seems like the playing field changes every week.
The playing field certainly has changed a lot, and particularly in the last 2 or 3 years. The fact of the matter is, when we go back to those maps and you have a lot of green, I think you hear a lot of the negative press. You hear a lot about the cases that go wrong. But really, what you have to look at when you're looking at your own operation is you have to look at your operation as a whole. You look at where you're doing business. You look at you have to look at the political climate of your particular state. There are a lot of different things that you look at to decide, is this the best model for me to be operating under? And you also have to look at the long-held industry standard of using owner-operators. This is something that's been around forever, and particularly in the long-haul sector, it's not really challenged all that often. Where we're seeing the challenges, it's more short-haul, drayage, final mile. Those are the places where we're seeing the focus. But we're also seeing, like I mentioned earlier, we're seeing additional legislation being enacted to counteract some of these bad decisions. And interestingly, the Uber cases might actually help the industry because when folks, I'm talking like I'm assuming everyone knows, but hopefully you've all seen there's a huge misclassification case pending against Uber, where these Uber drivers who are, who could be more like an independent contractor than an Uber driver? They're driving their own car, they turn on their phone, sign into the app or don't whenever they want. They can do it for an hour a day or 5 days a week, and they don't have to accept any particular ride. It's all of the hallmarks, everything you would think of as independent contractor status, and someone who's never even thought about independent contractor status is going to look at an Uber driver and say that's an independent contractor. And yet we have all of these misclassification claims coming from the Uber drivers, and the thought is that if those drivers are deemed to be employees, that is going to trigger legislation on a broad spectrum that will protect independent contractor-based status on a broader basis, because that's a sign that something's wrong. If not even those guys are independent contractors, what do we need to do? What do we need to say, there really can be independent contractors. Nobody's said being an independent contractor is illegal. What they've said is it's illegal to do it the wrong way. And so we think that the Uber litigation in a backwards way is actually a good sign that we might see a shift, sea change in the future. And again, that's going to depend a bit on what happens in the election cycle. But we'll see.
Have you seen any change in the courts where a contractor is hurt, now I want to become an employee, so I cover under the workers' comp by my employer?
Sure. Well, so with work comp claims, in all but about 6 or 7 states, occupational accident insurance is something that we recommend that most of our clients insure as a contractual standard, that their owner-operators have OCAC in the first instance. And the reason being, not because OCAC standing on its own is particularly useful in the defense of a misclassification claim, but because it can act as a deterrent to the extent the injured owner-operator has a source to go to for his injury, to get repaid. And there's less incentive then to file a work comp claim. Oftentimes with the OCAC policies also, the filing of the work comp claim can render their OCAC benefits void. So in those cases, it's an additional deterrent if they're looking to get recover some benefits right away. They're less likely to file that work comp claim. Leaving that aside, I think, so there's been, in the last 6 months, I think there have been at least 3 favorable cases. One of them was under Ohio law, one of them was under New York law, and one may have been Pennsylvania, but I'd have to check, where we have a circumstance where it's just that. We have an independent contractor, owner-operator, injured, files a claim, and says, I'm an employee. And we've had 3 good cases in the last 6 months where the court says, no, I've looked at the applicable test and you're an independent contractor. In that same period of time, I bet you we've had twice as many unfavorable decisions. And again, it's going to be state specific. It depends on the test applied. New York, I think we've seen quite a few unfavorable decisions. However, those unfavorable decisions are all under a previous version of the work comp statute. New York has, in the last 2 years, enacted something that's called the New York Commercial Goods Transportation Industry Fair Play Act, I think. And it's one where it's considered a fairly favorable act to motor carriers, but one piece of it that's important is that they're contracting with business owners, not with individuals. We haven't seen any cases come out where that's the statute being applied. So the cases that are coming out now are, the injury happened in 2009 in some instances. So we're looking back to old law. But then in the states where you have these owner-operator exemptions, and again, I think for work comp, there are at least 25, if not 28 states where they have specific exemptions that apply to owner-operators that, set out the factors, but say, for example, Indiana is if you enter a written agreement with the motor carrier to provide the equipment and driving services, and you are not required to personally perform those services, then you're deemed exempt from Indiana work comp law. So even if they bring that claim, the statute's a defense. Anyone else? All right, thank you very much. And if Brandon and I will be here for a few minutes, if anybody has any other questions we can answer, we're happy to do that.